which we must do in order to preserve this nation. And my Lord, today's occasion is being held at a time when the judiciary has been subject to relentless public accusation, discussion, publicly, possibly more than any other time in the history of Nigeria, where this scrutiny, constructive, there would hardly be any need, as it were, to dampen the mood of today's event with a critical examination of the state of our judiciary. My lords, the responsibility of the legal profession to educate the Nigerian public on the state of the law cannot be overemphasized. It is a duty that cannot be ignored or treated with levity, as to do so would be to the peril of the entire nation. By educating the public, we help shape the expectation of the public with regards to the justice that we all, as members of the legal profession, are called to serve either from the bench or bar to the people of Nigeria. And this responsibility or duty cannot be performed by any other person or profession. Only the bench and the bar can perform this sacred duty. Put differently, it is the sole responsibility of the members of the bench and the bar to dispense justice to the people. And if justice is, and yes, it is, at the core of the existence or survival of our nation, Nigeria, then it necessarily follows that the survival of this nation rests and lies in our hands. This, in a nutshell, describes or depicts the enormity of the responsibility which has been trusted on us by reason of the privilege of our membership of the profession of law, and we cannot afford to shirk the responsibility, as the consequence of doing so would be grave. The resultant effect of the application of this sacred duty is chaos and anarchy. We can all very easily say or pray to God to forbid chaos and anarchy, but humble and submissive as that may sound, merely saying or praying so in itself is an abdication. When God has given us all it takes to forbid a thing, it is abdication to look away from our God-given ability and call on Him, God Almighty, to step in to forbid what He has already given us the power to forbid. And we must act now and fast. It is therefore absolutely and uncompromisingly necessary that in the performance of our work as priests and ministers in the temple of justice, we remain focused and motivated by justice. Whenever we describe the lady's symbol of justice as blind because of the blindfolding, she is only blind to extraneous factors and elements. The sentiments or prejudices which distract and detract from justice, all that the Lady Justice focuses on and sees is justice. And I should add that the eyes by which she focuses and sees justice are the inner eyes. The inner eyes of the person of justice in members of the bench and the bar. This is the only way the light and illumination and transparency that comes with the presence of justice can be experienced by us who serve justice and those for whom justice is served. When the eyes of justice administered by the bench and the bar are focused, the entire polity, the nation, will be full of light, illumination, resulting in peace and development. This way, we achieve our role as socio-economic and political change agents of the society. My lords, there has never been a time in our history that judiciary came under attack like this time. And my lords would agree with me that more than 90% of these attacks stem from election-related matters, which in so many ways have affected the other matters being handled by the courts. The question is, why do we have the preponderance of these accusations arise from electoral matters in cases dealing with politicians and political interests? Of course, this is not a recent phenomenon, for indeed this court had, in the case of Buhari and INEC, Paniki Toby of blessed memory, observed thus. It is sad that so much has been said in the newspapers of this country on the case. The new technology of internet reporting has added to the comments, some of them doubting our integrity to do justice according to law. I regard them as blackmail. I will not succumb to blackmail. The way politics in this country is played frightens me every dawning day. It is a fight to finish affair. Nobody accepts defeat at the polls. The judges must be the final bus stop. And when they come to the judges and the judges in their professional minds give judgment, they call them all sorts of names. To the party who wins the case, the judiciary is the best place and real common hope of the common man. To the party who loses, the judiciary is bad. Even when a party loses a case because of a serious blunder of counsel, it is the judge who is blamed. Why? My Lord, I repeat, even when a party loses a case because of a serious blunder of counsel, it is the judge who is blamed. And my Lord Honorable Justice Nikitoli asked, why? The accusations and name-calling have, however, in recent times acquired a dimension that calls for grave concern and action. Whether we like it or not, it is these accusations, unfounded as they may be or can be, arising from these political matters that have largely shaped the public perception of the judiciary in Nigeria. Have we, members of the bench and the bar, who are privileged to be the ones to guide the public in regard to matters of justice, contributed in any way to fueling this negative public perception? There is no gainsaying that the duty to guide and provide direction to the people of Nigeria is the exclusive preserve of the legal profession. While this is a privilege, it also comes with responsibility. First, let me be clear. There is no ambiguity in the NBA position concerning the cacophony of unsalutary comments that have dominated much of the recent conversations about the judiciary over the last few months. We condemn these in absolute terms. I must particularly mention that it is regrettable that an unacceptable number of these armchair critics have come from the legal profession. The gale of unfounded allegations based on disjointed and jaundiced review of decided election petition matters by some of our colleagues cannot but be disconcerting. In all this, there is yet to be any specific evidence of impropriety. All that we have seen is general condemnation of the entire judiciary. My Lords, talking about our responsibility to provide direction, I referred to the statement by Christopher Alexis Sapara Williams, who noted that the legal practitioner lives for the direction of his people and the advancement of the cause of his country. I also found very relevant the statement by Sir Adetokunbo Ademola, CJN of blessed memory, who said the respect in which the bar in any country is held is the best indicator of the freedom in that country. My Lords, these are profound statements, and they are instructive and worthy of note and consideration in the discharge of our responsibilities. While the former speaks to all members of the legal profession, the latter is specifically addressed to the bar. We have a very critical role to play in society, and that is not something to be toyed with or taken lightly. The leading lights of the bar have largely remained silent when it comes to the education of the public on matters of law as it affects Nigerians. And this has greatly encouraged unprofessionalism amongst our colleagues. This silence has continued to thrive and has allowed all manner of information and misinformation to percolate through the consciousness of Nigerians and have succeeded in molding their psyche along the lines of twisted information, resulting in the attacks on the judiciary. Many unsavory and inflammatory remarks have been made and are still being made by members of the bar, denigrating and clearly inciting the public against the judiciary. Well laid down principles of law are twisted, tweaked, or taken out of context just to serve personal interests and not the cause of justice. These are made by persons who either deliberately misinform the public or do so out of sheer ignorance, not only of the law, but also of the facts on which the courts are called upon to apply the law. Neither of these two scenarios, my lords, is acceptable. Indeed, this is the point at which legal scholars, experts in the areas concerned, are expected to speak up through articles and journals to state the proper perspectives of the law, set the record straight, and provide guidance and direction to the public in line with our responsibility as legal practitioners to provide direction to the people. What is more pathetic is the internationalization of these views. These colleagues have decided that the solution to the challenges that we face at home is to tell the world that our judiciary and justice system are incapable of delivering justice. They talk about corruption in the judiciary with so much authority. It defies belief that even as lawyers, they see no need for any evidence to back up their claims. At the recent conference of the International Bar Association, a former Attorney General of one of our states, gleefully and without a care in the world, told an international audience that the Judicial Service Commission in his state, of which he was a member, was immersed in corrupt practices. In very lucid terms, shared the story of how judicial appointments in his state were being sold for as much as 10 million naira, with lawyers and judicial officers in his state trafficking in judicial appointments. Quite apart from his tragic unawareness of his surroundings, he saw nothing wrong in being the chief law officer of a system that allegedly trafficked in judicial appointments, did nothing as the Attorney General, but only to travel to Paris to render a report of his tour of duty in that manner. I have written the said Senior Advocate of Nigeria, Mr. Uche Ihedua, Senior Advocate of Nigeria, a letter to supply me with the details of the persons allegedly involved in the racketeering of judicial appointments. I wrote a similar letter to Mr. Mison Nejo, the lawyer who said on national television that his client informed him that he had bribed the chief judge for a matter he was handling on behalf of the client to do likewise. I find it amusing that these colleagues appear to be pitifully oblivious that the same international community see them as products of the rot they gleefully proclaim. Allowing such misinformation with deliberate distractions to pervade the minds of Nigeria would only lead to uncivilized reactions to the justice delivery system, with the attendant consequence of refusal to accept the product of the exercise, resulting to chaos and anarchy. Those who engage in election petition proceedings in Nigeria form part of the crème de la crème of the legal profession in Nigeria. When we hear or read these statements often made by our colleagues, many of them of the inner bar, we owe Nigerians the bounden duty to put the record straight and be deliberate about disseminating the true position of the law in order to keep the expectation or reaction of the public within the bounds of law. We all know that cases are fought by the parties and adjudicated upon by the courts on the basis of what have been presented by the parties. Talking about electoral matters, which is the focus here, it is the pleadings of the parties that circumscribe the limit of what the parties are allowed to do and the extent of what the courts are permitted to consider or look into. This is an elementary principle of law in every civil proceedings, but how many non-lawyers, members of the public know this? Or maybe we should also ask, how many lawyers know this? My Lord, I refer to a case of this honorable court where the role of pleadings in the context of any civil proceedings was clearly stated. It's a tried position of the law, and that it is what you present, it is the pleadings that circumscribe what you can do as a party, and it is the court is also bound by the pleadings that has been presented. The court is not permitted to go outside of the case that was presented before. And the bar must collaborate in the fight to salvage the nation. We expect the bench to expose any clear case of professional misconduct by members of the bar, while on the other hand, the bar must ensure that all efforts are made to expose provable allegations of judicial corruption. those members of the bar who claim justices collect bribes should quit being cowards and make bold to present the evidence to law enforcement agencies, even when the bribes are allegedly given by or through them. It is a sacrifice that we must make to save the nation. I recall in a book I read where a lawyer had to go and give up his client because I think it was in Chicago, one of these drug barons. They couldn't find any evidence against him, and the lawyer was fed up. Each time they went to court, he went scot-free. He was the one that provided the evidence. We can be bold enough to do that. Otherwise, going around to accuse judges and justices of corruption without any evidence is even worse than the corruption itself. Let us be bold to come out and do that. I therefore call, my Lord, on the judge who alleged that a senior counsel attempted to bribe the tribunal in Kano to also furnish us with the evidence of that senior member of the bar that attempted to do that. And my Lord, if this cannot be done, because the allegation that was made was unfounded, the bar with respect demands an apology, just as I have severally done for the unwarranted hurts caused your lordships by members of the bar. I must in this wise commend the Court of Appeal, by Honorable Justice Ugo Moses and Bolaji Yusuf, Justices of the Court of Appeal, in the bold step of calling out on condemning the actions of members of the bar who derided and treated the courts derogatorily. And my Lord, I'm making reference to the Presidential Election Petition Court, when the Court of Appeal sat as that court. With due respect to this honorable court, the failure of your lordships to invoke the court's coercive powers, despite the discourteous and irreverent manner in which some members of the bar treated the court in the wake of the presidential appeal proceedings before the court, the threats, outright abuses, and derogatory remarks after the proceedings did not help in sending the right signal to the public and worsened the perception of the public about the court and the judiciary at large. That the court did nothing, my Lord, did not punish any of those who clearly went on a spree to denigrate the courts and the institution of the judiciary made the public think that what was said of the court were true. Much as some of us in the bar do appreciate the basis of your lordship's silence over such despicable and unprofessional conduct, which was consistent with your lordship's code of conduct as judicial officers, it was, in my opinion, counterproductive. At the minimum, your lordships would have handed down some hard strictures that would automatically have served as a basis for disciplinary proceedings against the erring members of the bar. Until such examples are made, many would continue to lend their licenses to practice law as a tool to serve the whims and caprices of their clients at the detriment of the profession and the country at large. While we know that this honorable court recognizes the fundamental rights of citizens to free speech and access to justice, these rights must be exercised within the ambit of the law. They are not open-ended rights. Motion pictures which have depicted silly and sometimes dishonest court proceedings. Some criticisms have been justified, but many have not. Courts have suffered bitter censure for unpopular positions they have been compelled to take, positions which were absolutely sound in law and were necessary for the welfare of individual and nation. When judges have been subjected to the sting of false and misleading statements, it is shocking to them as individuals. This in itself may not be so important, but it is important in the extreme when the prestige of their courts is hurt. Let me be clear. We have no fault with just criticisms. Citizens have the right to criticize. Indeed, one object of bringing citizens to confer with lawyers and judges is to get constructive criticism. But we like criticisms to be just and to be based on facts. In the preface to the book Judicial Activism in India, my Lord, the learned author of that book, talking about the role of the Supreme Court in India, said this: An analysis of the judicial behavior of the Supreme Court in the last 2 decades clearly shows that public adulation has not swayed the judges much, and personal aggrandizement has been eschewed successfully, barring a few stray incidents. And my lords have demonstrated that strength of character when your lordships will not allow executive order 10, even when it was meant to serve the interest of the court. Your lordship stood your grounds to say that the act of the president was unconstitutional, and your lordships will not endorse what is not constitutional. My lord, he continued, the judicial activism is no activism if it is not accompanied by judicial accountability. As Justice Robert Jackson of the United States Supreme Court said, we are not final because we are infallible. We are infallible only because we are final. The Supreme Court continues to be supreme but not infallible. Another development that needs to be mentioned in this context is the exercise of contempt power by the judiciary in recent times. There have been a few occasions when the judiciary appeared to have become a little oversensitive to constructive criticism. In the words of Justice Krishna Iyer, free speech is a fundamental right, so too free access to justice. To strangle both these freedoms because the courts are allergic to what they regard as savage criticisms is to foster judicial tyranny and tantrum. But my lord, the author added, at the same time, it is always better to remember that where the contemner is a foolhardy bully or literary terrorist, corrective sword should be unsheathed. I commend this approach to your lordships for the many judicial bullies and literally terrorists in this country. This honorable court must, in the overall interest of the country, unsheath its heavy corrective sword accompanied with judicial accountability. Although I have severally made the point clear, I will say it again for avoidance of doubt. I am by no means condemning in totality the criticism of judgments of court. However, as I have always said, such criticisms must be constructive, done through well-researched articles, academic papers, books, scholarly debates, and panel discussions, not personal insults and attacks on the judicial officers. On this point, my lord, I will refer to a book written by one of us, a senior advocate of Nigeria, Chief Charles Maikyau, Constitutional Law in Nigeria through the judgments of the Supreme Court, where he dissected some of the dissenting decisions of this honorable court and how judgments were delivered on the basis of what was presented by the parties. My lord, I now turn my attention to other challenges facing the judiciary and the justice sector, even without the gale of election petitions that appear to have, in many ways, taken over our justice system. There is something fundamentally wrong with the justice system that shuts down at the end of every electoral cycle. It is a paradox of some sort that the judiciary is at the receiving end of problems that it did not create. The judiciary neither enacted the laws that govern the electoral system nor appointed persons saddled with the management of the process. It is certainly not the judiciary that removed the spirit of conceding defeat from our politicians, even those politicians who by any stretch of imagination and under any circumstances cannot win community association elections, have resorted to challenging presidential elections in our courts. Our colleagues who are now deeply emotionally tied to the politics of the moment should know that this season of anomie will pass, and what will remain forever is the legal profession and the justice system in which we eke a living. My lord, talking about eking a living from the legal profession is even a selfish concern. What is fundamentally important is the fact that this attitude and conduct, if not curbed, will only result in the collapse of our nation, and we cannot afford to let that happen. I share the concern of many of my colleagues about our collective inability to make rapid progress on the judicial reform. Every aspect of our justice system and institution requires rethinking in significant ways if we are to achieve our desire of a justice system that works in the interest of all Nigerians. I hear those who want to know what the NBA is doing. The record of achievements of the Nigerian Bar Association during its more than 90 years of existence emphasizes that it is a dynamic force in improving Nigeria's justice sector, including the maintenance and defense of the integrity and independence of the judiciary. However, it is important to note that the NBA has no compulsive power either over individual lawyers or government agencies. We have no legislative or executive or judicial power. We have no patronage to dispense, no palliatives to distribute. Our powers are solely those of deliberation. We succeed so far, and only so far as we are able to appeal to reason and conscience of decision makers. We are leading from the front. The judiciary and indeed the justice sector is indispensable to the sustainability of our judiciary. In fact, despite all the hullabaloo, the indispensability of the judiciary has been affirmed. That is, what is now beyond doubt is that the current constitutional framework that governs our judiciary is not sustainable. There is an urgent need for a radical review of all aspects of adjudication, from the appointment of judicial officers to matters of case management, including limiting matters that should be heard by the Supreme Court. It is for these reasons that the Nigerian Bar Association Judiciary Committee, led by Babatunde Ajibade, Senior Advocate of Nigeria, has over the past couple of months undertaken an inclusive consultative process aimed at putting forward a comprehensive NBA position on judicial reforms. We shall shortly be presenting our position to the National Assembly as part of the ongoing constitutional review process. We are also concerned about the condition of service of judicial officers. My Lord, talking about case management, one of the senior advocates to be conferred today, Isaiah Bozimo, was in his mommy's tummy when his father argued an appeal, and he argued a case at the trial court and ended up arguing the appeal at the Supreme Court himself. The child